1947. So the Industrial Employment Standing Orders Act 1946. So the major purpose of having this particular act is uh, there are so many laws which have been really did not connect with the employment or the labor practices. So the workers did not have any uniformity in their service conditions as enforced by the Standing Orders Act. So for this disruptions and the loss between the workers and the employers, so the Labor Committee in the year 1944 and 46, they created a law and which was immediately spotted the key cause of issues. So there was a lack of understanding on the part of the employees as well as about the employment conditions, the terms of the conditions. So this committee mentioned that the workers had a right to know all the terms and conditions relating to their work and employment. And they even wanted a distinct central law, which made it obligatory for the employers to frame and approve employment conditions. So the result is the enactment of the Industrial Employment Standing Orders Act 1946. And the terms and the definitions of the law, we have the appellate authority, which means an authority appointed by the appropriate government by the notification in the official gazette. And then we have the appropriate government, that is in respect of the industrial establishment. So under the control of the central government or the state government, wherever the rules apply, that would be the appropriate government. And who is the certifying officer? A labor commissioner or a regional labor commissioner, and includes any other officer appointed by the appropriate government by the notification in the official gazette is considered as the certifying officer. And employer means the person who has actually owns the industrial establishment, and it can be a factory or any person named. He can be a manager of the factory. In any industrial establishment under the control of the Department of the Government of India, the authority appointed by such government would be the on his behalf if he is appointed. And in any industrial establishment, any person responsible to the owner for the supervision and the control of the industrial establishment. Now, what is an industrial establishment? An industrial establishment is defined in Section 2 under the Payment of Wages Act 1936. And a factory has been defined under Section 2 of the Factories Act 1948. And a railway as defined under the Clause 4 of the Section 2 of the Indian Railways Act 1890. And the establishment of a person who, for the purpose of fulfilling a contract with the owner of any industrial establishment, employs workmen. So the prescribed means the rules made by the appropriate government under this act. Standing orders are the rules relating to the matters set out in the schedule, that is with reference to the classification of the workmen, manner of intimation to workmen about the work, wage-related details, attendance and conditions of granting leaves, rights and liabilities, the suspension, termination, and the conditions for that. Okay, the redressal of the workmen. So all these things are mentioned in the standing orders. And as already defined, a trade union is a union which has been registered under the Trade Unions Act 1926, and the wages and the workmen have meanings respectively, which have been assigned under the Industrial Disputes Act 1947. Now, coming to the object and scope, the object of the act is to enforce uniformity in the conditions of the services under different employers in different industrial establishments, to bring uniformity, because each worker is appointed in different industry. They have their own set of rules and regulations, terms and conditions. So there is no uniformity. One industry might differ with that of another industry. So to bring uniformity, the first and foremost object of this act is, and the employer once made the conditions of employment known to, it has to be known to his workmen, and those conditions cannot be changed. And the same conditions, whatever have been maintained at the time of the appointment, should be there. I mean, the conditions which are known to the workman should be maintained and continued. And then you have the express. With the express or written conditions of the employment, it is open for the prospective worker to accept and join the industrial establishment, and also for maintaining industrial peace and continued productivity. The significance of the express conditions have to be termed in the employment, and they cannot be minimized or they cannot be exaggerated. Okay, so the major purpose of this act is to bring uniformity. I mean, the standing orders are same whether you're working in any of the industrial establishment, and the definition of the worker will also not change. And the scope of the act, it extends to whole of India, and it applies to every industrial establishment wherein there are more than 100 workmen employed, and within the preceding 12 months, within the previous year, that 100 employees or more have to be appointed. And further, the appropriate government may, after giving not less than 2 months notice of its intention to do so by the notification in the official gazette. And coming to the certification of draft of standing orders, first of all, the submission of draft standing orders by employers to the certifying officer. As per this, Section 3 provides that within 6 months from the date on which this act becomes applicable to an industrial establishment, the employer of that establishment shall submit to the certifying officer 5 copies of the draft standing orders proposed by him for the adoption in that establishment. And once the standing orders were confirmed, the model standing orders shall contain every matter set in the schedule which can be applicable to the industrial establishment. And the conditions for the certification of the standing orders according to Section 4 of the Act, provisions is made therein for every matter stated in the schedule to the state which is applicable to the industrial establishment, and the standing orders are otherwise in conformity with the provisions of the Act. And the fairness of reasonableness of standing orders should be maintained. I mean, whenever you're framing the standing orders as an employer, you should be reasonably fair enough in maintaining the conditions, whatever you're mentioning as an employer in the standing orders, in the draft standing orders. And once the certification process, now what is the certification process? This is dealt under Section 5 of the Act. So the certifying officer to send a copy of the draft standing orders to the workman or to the trade union, along with a notice calling for the objection, and this objection should be submitted within 15 days of receiving such notice. So whatever draft standing orders which have been sent by the employer to the authority for the standing orders in the industrial establishments, the same copy will be sent to the trade unions or to the workmen, and whether it is acceptable or there is any objection where they feel that that has to be changed, such information has to be provided within 15 days of such receipt of the notice. Upon the receipt of such objection, the employer and the workman to be given an opportunity of being heard, where both the parties can give their opinions. And finally, the certifying officer shall certify such standing orders, and thereby within 7 days send a copy to the of annexed with this order for modifying passed under Section 5(2). So within 7 days, the standing orders will be passed. And appeals. Any related party aggrieved by the order of the certifying officer may appeal to the appellate industry or the authority within 30 days. Okay, so provided that its decision of confirming such standing order or amending is changing, is, I mean, it shall be final. Okay, under such cases, within 30 days, they can appeal to the appellate authority. And the date of operation, register and posting of the standing orders or the amendments made in the standing orders shall, unless an appeal is preferred under Section 6, come into operation on the expiry of 30 days from the date on which authenticated copies are sent under subsection 3 of the section 5. Okay, so within 30 days, if there is no objection, no modification, such order will be passed and it is applicable. The register of the standing orders, a copy of all the standing rules with all the amendments as finally certified under this act shall be filed by the certifying officer, and the certifying officer shall furnish a copy to any person applying thereof on payment of the prescribed fee. And the posting of the standing orders by the employer in English and other major general other language newspapers or uh, uh, whatever the posting of the orders is there, that should be posted in the employer in English and other languages, wherein the workman can see visibly the board. On the notice board, it has to be published, it has to be posted so that it is visible to every workman. And the duration and modification of the standing orders, a certified standing order cannot be modified unless there is an agreement between the related parties until 6 months from the last modification. So if any modification is required, so at least for a 6 months period, they have to wait until the last modification period of 6 months expires. Both the parties cannot apply, either of the parties, and both the parties should agree for the modification, and then only the modification can be dealt. So payment of subsistence allowance. Section 10 of the Act stipulates for the payment of subsistence allowance by the employer to a workman who is suspended or there is a pending investigation or inquiry for his misconduct, and how much should be the payment at the rate of 50% of the wages which the workman was entitled to immediately preceding the date of such suspension for the first 90 days, and 75% of such wages for the remaining period if the delay is not attributable to the workman. So 50% immediately for 3 months and 75% and if the delay is not on the part of the workman. Now, temporary application on the model standing orders. So anything contained, notwithstanding anything contained under section 3 to 12 for the period commencing on the date on which the act becomes applicable to an industrial establishment, from that date, uh, the prescribed model standing orders shall be deemed to be adopted in the establishment, and this is as per the provisions of section 9 and subsection 2 of section 13 and 13A. And coming to the penalties and the procedures, the Act makes it a penal offense in case of a violation of Section 3 or 10 of the Act by the employer. And there would be a fine of rupees 5,000 and an additional rupees 200 per day for a continuing offense. And there is also rupees for the infringement of the CSO, a fine of rupees 100 and an additional 25 rupees for continuing the offense. And the section declares that no prosecution shall be instituted unless it is taken the prior approval by the appropriate government. So that is how the standing orders work. And then you have the Industrial Disputes Act 1947. So the first enactment dealing with the settlement of the industrial disputes was the Employers and the Workmen Disputes Act 1860. And then we had the Trade Unions Act 1926, the Trade Disputes Act 1929, and the Act of 1929 contains special provisions regarding the strikes in public utility services and the general strikes affecting the society and the community as a whole. So the main purpose of this act is to provide a conciliation machinery to bring about a peaceful settlement of industrial disputes. So conciliation is where both the parties agree for a conciliator, a third party who is going to intervene and solve the industrial disputes. So here, coming to the definitions of the act, again, the appropriate authority or the appropriate government means the central government in relation to any industrial disputes concerning any industry carried on by under the authority of the central government, or it can be the central and state, or it can be the state government alone. Award means an interim or a final determination of any industrial dispute where you try to give a verdict, okay? And then you have the industry. It is any business. It's a place where any business or trade or manufacturing process takes place. Industrial disputes is nothing but any dispute or difference between the employers and employers, or it can be between the employers and the workmen, or it can be between the workmen and workmen. And this difference is connected with the employment and sometimes the non-employment in terms of employment conditions, the dispute might be prevalent. And what is settlement? Settlement means arriving to a conclusion, to a decision, to some kind of a conciliation wherein both the parties will try to win something and lose something. And the wages are the remuneration which is payable to the workers, and such allowances including DA as the workman B is entitled, and the value of any house accommodation or supply of light, water, medical attendance or any other amenity or service at a concessional supplying date. Any traveling concession, but excludes the following, that is the bonus and any contribution paid or payable to any pension fund. And public utility means a railway service or a transport service or any service in connection with the working of the major port or dock. It can be industrial establishment, any postal, telegraph or telephone service, or it can be any industry which supplies power, light, or water to the public, or it can be a conservancy or sanitation. So anything can come under the public utility. Now, coming to the object and the scope, the Industrial Disputes Act 1947 came into force on the first day of April 1947, and it aims to protect the workmen against victimization by the employers, and the act applies to whole of India. Now, coming to the dismissal, etc. Difference between the workman and the employer connected might be leading to an industrial dispute, and the dismissal of the workman is nothing but discharging the workman or retrenchment of the workman or the termination of the workman from his service. No longer the worker or the workman is going to continue in the service. Such is called the dismissal. Now, the dismissal, that is the dispute settlement authorities under the Act are, we have so many committees, like works committee is there, conciliation officers are there, board of conciliation is there, court of inquiry, labor tribunals, industrial tribunals, and national tribunals. So what is a works committee? So in an industrial establishment where you have 100 or more workmen are employed in any working day preceding the 12 months, the appropriate government may require the employer to constitute a workmen committee or a work committee. So the work committee, it consists of equal number of the representation of the employers and workmen, and they are engaged in the establishment of works committee, and they try to call upon both the parties, hear both the parties, and try to come to a solution, and the solution is conveyed to the parties. And a conciliation officer is a person who has been appointed by the appropriate government, and the conciliation officer has a duty of mediating. He'll be a mediator where he's not a person from the employer's side, nor from the employees or the workman's side. He'll be a third party, a neutral party, and who is going to listen to both the parties, and based on the problem, an ultimate solution will be given, which is, which is both acceptable to the employer as well as the workman. And if the conciliation officer fails to resolve the dispute between the parties, he should report the same to the appropriate government, and then the dispute will be referred to the board, conciliation board, or to the labor court, or tribunal, or national tribunal, and this is done by the appropriate authority. Now, what is Board of Conciliation? For promoting the settlement of the industrial dispute, the appropriate government might constitute by notification in the official gazette a Board of Conciliation. So, the board shall consist of a chairman, and 2 or 4 other members as the appropriate government thinks fit. And it shall be the duty of the board to try to settle the industrial dispute. And they start investigation the moment the board has been constituted. So the board will try to call both the parties, sit with them, discuss with them, and they try to come to a conclusion, and then uh, they try to solve the problem. And in case if a settlement is arrived, the board shall forward the report to the appropriate government saying that these are the steps taken by the board in the settlement of the dispute. And the board will also enlist the reasons on account of which, in its opinion, a settlement could not be arrived. Okay, so wherein if it is settlement, uh, the the situations, the enlisted conditions on which the settlement has reached. If it is not reached, the reasons and also the recommendations will be submitted to the appropriate authority or the government. And then we have the courts of inquiry. The government can intimate a court of inquiry. So this court of inquiry will try to find the matters connected, and they will try to resolve the industrial dispute. And where a court consists of a 2 or more members, one of them shall be appointed as a chairman. And the court of inquiries looks into only the matters which have been referred to it by the government. And they have to submit a report to the government, and this should be within a period of 6 months from the commencement of the inquiry. And then we also have labor courts under Section 7. The appropriate government is empowered to constitute one or more labor courts for the adjudication of the industrial disputes. Generally, whenever the courts are involved, we call it as adjudication, and the members appointed will be one person shall be appointed by the appropriate government, and a person shall not be qualified for appointment as per the presiding officer of a labor court unless he has been a judge of a high court, or he has for a period not less than 3 years been a district judge or an additional district judge, or he has held any judicial office in India for not less than 7 years, and he has been presiding officer of a labor court constituted under any provisional act or state act. And once the industrial dispute has been referred to the labor court for adjudication, so it is the duty of the labor court to hold proceedings and submit a report, or it can also give an award and submit the report to the appropriate authority. And it should also give the reason or the conditions on which the uh, verdict has been given or the award has been given. And if it is not able to solve the case, the same thing has to be submitted as a report to the appropriate authority. And the tribunals, the appropriate government by notification in the official gazette, constitute one or more industrial tribunals for the adjudication of the industrial disputes, which are relating within the specified schedule of, it can be relating to the second schedule or the third schedule. And here, the appropriate government may appoint 2 persons as assessors to advise the tribunal in proceedings. And the duties of the industrial tribunal were more or less are identical with the duties and the responsibilities, just like the labor court. And with reference to any industrial dispute, the tribunal shall hold its proceedings and submit an award to the appropriate government. And we also have national tribunals. The central government alone has been empowered to constitute one or more national tribunals for the adjudication of industrial disputes. And they involve questions of national importance and whatever the national importance are there, the dispute is relating to the income or the harmony and the peace of the industries at the national level. Under such cases, the national tribunals will be constituted, and the case will be referred to them by the government. And no employee uh, will not, who proposes to effect any change in the conditions of the service applicable to the workman in respect of any matter specified in the fourth schedule shall effect such change without giving the workman a notice which prescribes the change, and the change can be the matter of the change proposed, and within 21 days of giving such notice, the proposal of the change cannot be applicable. And provided that no notice shall be required for effecting any such change, where the change is effected in pursuance of any settlement or award, where the workmen likely to be affected, the change are persons to whom the fundamental and supplementary rules, civil services, and the rules, revised rules, civil services regulations, civilians and defense services. Okay, so unless the change has been awarded by the conciliation or any other board, the intimation is must. And a change in conditions of the service during pendency of proceedings. So Section 33 prohibits the employer from bringing any change to the prejudice of the workman in the conditions of the service when there is any pendency of the inquiry before the conciliation board or labor court or tribunals or national tribunals. And change in the conditions of the service, when is it permissible? Uh, Section 33, subsection 1 prohibits the employer from changing during the pendency of any proceedings the conditions of service relating to the matter concerned with the dispute. So whenever there is any the situation is pending before the courts or board or conciliation boards, no such change is acceptable, and it is prohibited that the employer tries to change the conditions of the workmen's working conditions. And then we have grievance redressal machinery. Now, this is incorporated under Chapter 2B of the Act. Every industrial establishment employing 20 or more workmen shall have one or more grievance redressal committee for the resolution of the disputes. And the grievance redressal committee shall consist of equal number of members from both the employer and the workmen. And the chairperson of the grievance redressal committee shall be selected from the employer and from among the workmen alternatively on rotation basis every year. And the total number of members of the grievance redressal committee shall not exceed 6. And the grievance redressal committee may complete the proceedings of its inquiry within 30 days on the receipt of a written application on the behalf of the aggrieved party. And the workman who is aggrieved of the decision of the grievance redressal committee may prefer an appeal to the employer against the decision from the date of the receipt, and nothing contained in the section shall apply to the workman for whom there is an established grievance redressal mechanism in the establishment. So once you apply for the redressal, and if the grievance redressal is not acceptable, the same thing can be referred to the higher authorities, to any boards within 1 month from the date of such appeal. Now, the reference of disputes to the boards, courts, and tribunals based on the inquiry, and if the aggrieved party is not satisfied with the grievance redressal verdict, so he might apply within 1 month to the tribunal or court. And the voluntary reference to the disputes to arbitration. Now, the particular dispute, the aggrieved dispute can be referred to the arbitration. In arbitration, generally, you have a neutral person appointed as arbitrator, and he listens to both the parties, and based on that, they might try to give a verdict or a decision to both the parties and try to settle the particular dispute within the industry. Now, the procedure and the powers and the duties of the authorities. So, they have the rules which are made in this behalf for an arbitrator or a board or court of labor or tribunals or the national tribunals. So here they have to follow the rules which have been laid down in the procedures. So they have to, every board will try to enforce the attendance and also examine him on oath. And any additional evidences are there, those documentary evidences or the material objects should be produced. And if any witnesses are there, the board or the committee have to listen to them. And in such cases, any other matter referred will be taken care. And once they go through all the details subject to the rules which have been made, and based on that, they try to examine the material facts and truths and try to pass on their verdict. And powers to give appropriate relief in the case of discharge or dismissal. So where an industrial dispute relating to the discharge or dismissal of a workman, it has been referred to the labor court or tribunal or national tribunal for adjudication. And in the course of adjudication proceedings, the labor court or the tribunal or the national tribunal, in case if it is satisfied that the order of discharge or dismissal was not justified, so it may by its award set aside the order of discharge or dismissal. Now, coming to the awards or decree, the award of the labor court or tribunal or national tribunal shall be in writing and shall be signed by the presiding officer. And every arbitration award and every award of a labor court or a tribunal shall be within the period of 30 days. And the award will be published, shall be final, and shall not be called in question by the court in any manner. An award shall become enforceable on the expiry of 30 days from the date of its publication. And an appropriate government or the central government within 90 days from the date of publication of the award make an order rejecting or modifying the award. And if no pursuance has made, the order becomes enforceable after the expiry of 90 days. So this is the procedure. And coming to the strikes and lockout, strike means it is a cessation of a work by a body of person employed. That is, he doesn't want to work. The stoppage of the work has occurred. And it can be a number of persons who are employed under one employment. Now, what is the procedure for the strikes? No person shall employed in a public utility service shall go on a strike in breach of contract. That is, he has to give proper notice to the employer and that there's going to be a strike. So, what would be the notice of strike period? So, within 6 weeks before the striking. So, before 1.5 months, the notice has to be given. Within 14 days of giving such notice or after the expiry of the date of the strike specified in any such notice and during the pendency of any problem before the conciliation board, a strike should not be called. Lockout means it is a temporary closing of a place of employment or suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. So a lockout is temporary closing of the place of work. Now coming to the procedure, uh, without giving any notice, that is 6 weeks notice is 6 weeks notice is mandatory, and within 14 days of giving such notice before the expiry of the specified lockout period or whenever there is any pendency of the conciliation board, lockout is not valid. Now, what is this 14 days and 6 weeks? So, the clause A and B appearing in subsection 1 and 22 are significantly incorporated to prohibit the workmen as well as the employers to go on a strike immediately the day they decide. Whenever something is going wrong, they cannot simply declare a lockout or a strike. So this period is minimum period has been given to protect the interest of the employment. And generally, whenever there is any pendency proceedings before the conciliation board or labor court or national or industrial tribunals, generally the strike or lockouts are not acceptable. They are considered as illegal. Illegal strikes and lockouts shall be if the, I mean, if the period has not been followed or it is in contravention of subsection 3 of section 10, then we call it as an illegal. And where a strike or a lockout in pursuance of an industrial dispute has already commenced and is in existence at the time of the reference of the dispute before a board or a labor court, it is considered as illegal. A lockout declared in consequence of an illegal strike or a strike declared in consequence of an illegal lockout shall be deemed to be illegal. Justified and unjustified strike. So, strike is a legitimate weapon of labor, and it is equally important to keep in mind that indiscriminate and hasty use of this weapon will definitely hinder the industrial growth or welfare. Similarly, lockout is also not advisable all the time. It is not a weapon. So, definitely the industrial growth will be hampered whenever such lockouts happen in the organization. Okay, so coming to the wages during the strike period, it depends upon whether it is a justified strike or unjustified strike. So there are several factors and service conditions of the workmen wherein the wages to be paid during the strike period or not. No wages are payable if the strike is illegal and it is unjustified. And if the worker is indulging in any violence, no wages will be paid even when the strike is legal or justified. And justification of lockouts and wages for the lockout period during the lockout. And if it is a justifiable lockout, the wages for legal lockouts, no wages are payable to workmen. But where the lockout through legal is declared with the notice of victimization of workmen or has been continued for unreasonable period of time, it is unjustified and the workmen are entitled to wages. And dismissal of workmen and illegal strike. So whenever there's a dismissal, so these are the important principles. The inquiry should be conducted in unbiased person with by an unbiased person, and the inquiry should be honest, and the employee should be given a fair chance of being heard, and the preliminary inquiry has to be taken, and based on that, the verdict should be taken. And layoff and retrenchment. Layoff describes the act of an employer suspending or terminating a worker. Either it can be temporarily or permanently for reasons other than the employee's actual performance. So it can be the non-availability of the material or the change of fashion or anything it can. And whenever there is a layoff, there's the workman, the compensation has to be paid. There's a right for the workman to claim for the compensation. And moreover, what do you mean by the minimum days allowed in layoff, employee by employer? So according to section 25, a 45 days is the minimum period where the employee can be laid off, and he is entitled for a compensation equal um, for 50% of the total of his basic wages and DA. And within the workmen's, they are entitled for compensation in certain cases. That is, if he refuses to accept any alternate employment, he is not entitled for compensation. If he does not present himself for work at the establishment at the appointed time, he will be denied of the compensation. And if such laying off is due to the strike or slowing down of the production, he will not be paid any compensation. Now, retrenchment means the termination by the employer for the service of the workman for the reasons whatsoever, which cannot be, other than the punishment. It can be voluntary retrenchment or retrenchment of the workman on reaching the age of superannuation, or it is the termination of the service of the workman on the ground of continued ill health. Now, whenever there is a retrenchment, you have to give an opportunity to the workman to come to his establishment and come to an agreement for the retrenchment. And sometimes the retrenched workman might be re-employed in the organization. So what are the conditions? Employee should be having continuous service for not less than 1 year under the employment. and compensation which shall be equivalent to the 15 days of average pay for every completed year of continuous service. 3 months notice in writing should be given for the retrenchment. An application for permission to specified authority for the intended retrenchment and a copy of such application shall be submitted to the workman, and compulsory permission from the competent authority by the employer retrenchment of the workman. Now, coming to the unfair labor practices, and if the employers and the trade unions they find that there are any unfair labor or practices, so the trade unions will try to interfere and try to see that there is just the moreover, whenever we see that there is unfair labor practice, some of the labor practices which are unfair can be the interference or the restrainment or the dominance or interference or employer sponsored trade unions, or it can be to recruit workmen during a strike period, failure to implement an award or a settlement. So all these are considered as unfair labor practices, wherein the unions are advised to, even the employer is not advised to follow such kind of illegal practices. Whenever there's anything relating to the industry, the dispute should be solved amicably rather than following the unfair trade practices. And the penalties are levied by the appropriate authority. The penalty can be 50 rupees fine, and it can be also imprisonment of 1 month, and penalty for layoff and retrenchment. It can be again a fine of 1,000 rupees, or it can be a month's imprisonment. For unfair trade practices, again 1,000 rupees fine and 6 months imprisonment. So in this way, you have different set of penalties which are levied whenever the offenses are committed either by the party, that is either by the employer or by the employee. Now, coming to the next subheading is block 3, where we have the legislations on wages and salaries. The first one being the Payment of Wages Act. So the Payment of Wages Act is introduced in the year 1936, and it has come into the force on April 23rd. Wages are something which are paid by the employer to the employees for the service what they have done in the organization. Now, as I already said in my earlier lectures, that the employees or the workers have very weak bargaining power. They don't know how to bargain. They are very weak. They are illiterate. They don't know the norms of the employment. So in a way, the employer will try to pay very less wages. Sometimes give the minimum wage, which is not even sufficient for them to survive. So to protect the interest of the workers or the working class, the act has come into the being. The object of this act is to ensure regular and prompt payment of wages and to prevent unauthorized deductions and arbitrary fines from the wages. Okay, so the earned wages of the employed person shall be paid, and these should be paid timely, in time, and the regular payment of the wages is must. And the act also says that the deductions of the wages for the unlawful things and the fines, all these should not be imposed. And the act declares contracting out as null and void, whereby an employed person give up any right conferred on him by the act, and the act does not apply to the persons whose wages exceed rupees 1,600 per month. Now, it is applicable to the persons employed in any factory, persons employed otherwise than in an industry factory, or the persons applied in the railway or by railway administration or any other industrial establishment, and the person's wage is less than 18,000 per month. Therein, the act is applicable. Coming to the definitions, employed people. This includes the legal representatives of the deceased employed persons. Employer, the legal representative of a deceased employer. Factory, a place where the manufacturing process takes place. Industry or other establishment, it can be a tramway or motor transport services engaged, carrying the passengers or goods or both. It can be a jetty, it can be a dock, it can be an inland vessel, oil fields, quarry, okay, and a plantation. It can, when we are talking about the wage, what is the wage? It is a remuneration payable under any award or settlement, remuneration in respect of overtime, holiday, leave period work, additional remuneration payable under the terms of the employment, and any sum to which the persons employed are entitled under any other scheme. And it does not include any bonus. Bonus is nothing but the profits of the firm or the company shared. And it will not include any value of house accommodation or supply of light, water, medical attendance, or any other amenity which has been or service excluded from the computation of the wages, pension or provident fund, travel allowances, or any sum paid by the employed person, any gratuity payable. Now, the responsibility of the payment of the wages will be vesting with the employer, and in factories, the person named manager will be paying. In industrial or other establishment, there's a person responsible to the employer for the supervision and the control of the industrial establishment. And upon railways, we have the employer is the railway administration, and the railway administrator who has been nominating a person on behalf of the local area concerned. Okay, so these are the people who are eligible to pay the wages, and the fixation of the wage period. The person responsible under the Act for the payment of wages shall fix the wages uh, based on the rules of the factory and the terms and conditions. And whenever the wage period, we say it should not exceed 1 month. And time for the wage payment in case of the railways and factory establishment in which less than 1,000 persons are employed before the expiry of the seventh day after the last day of the wage period in respect of which the wages are payable. So every month, 7th should be the date. In case of wages, in case of other cases, before 10th of the every month, the wages have to be paid. Okay, and all payment of wages shall be made on a working day, and the mode of payment of the wages will be shall be paid in currency notes or current coins or both. Now, nowadays, I think it is the bank, the amount is being directly credited to the banks. Now, so even that is also one of the method of payment of wages. And coming to the deduction from wages, now what are the kind of deductions? The following kinds of deductions are permitted under the Act. Fines. An employed person can be fined only for acts and omissions which are specified in the list, and the list must be exhibited in the place of work. Before the fine is imposed, he must be giving an opportunity to the workman to present his case, and the total number of fines which can be imposed upon a person in any period must not exceed an amount equal to 3 paise in the rupee of the wages payable to him during the wage period. And no fine can be imposed on a person who is below the age of 15 years. And no fine can be recovered by installments on or after the expiry of 60 days from the day on which it is imposed. Every fine shall be deemed to have been imposed on the day of the act omission in the respect of which the fine has been imposed. And absence from the duties, the ratio between the amount of such deductions and the wages payable must not exceed the ratio between the period of absence and wage period. Damage, damage or loss, accommodation and service, recovery of advance, any recovery of loans, any payment to cooperative societies and the insurance schemes, other deductions. Illegal deductions, any deductions other than those authorized under Section 7 of the Act will be constituted as illegal deductions. Now, the limit of the amount of deductions, it can not exceed 75% of the wages, and in other cases 50% of the wages. it should not exceed the deductions. And you need to maintain the registers and the records whenever the payment is made. It can be the following particulars shall be there in such registers, that is the persons employed, work performed, wages paid in advance, given deductions from such wages, and the receipts which have been given to the wage payers. And the obligations of the employer under the Act, the Section 5, it fixes the wage period exceeding 1 month. Section 14, to afford facility to inspector for entry and for the inspection and the supervision. Section 25, to display abstract of the Act and the rules. Section 25, to deposit the payment of undisbursed wages within the prescribed authority in case where the wages have not been claimed by the person, any particular person. Now, coming to the authorities and their duties, the powers and the procedures. Now, coming to the inspectors, in respect of all persons employed under the railways or a factory, any such case, or in respect of the persons employed in factories, uh, the power of the inspector is to make examination. They can enter any premises, make an inquiry, and they can refer the wage registers, check the payrolls, and they can supervise the payment of the wages. Okay, so all these things will be taken care by the inspectors, and all the claims arising out of the deductions from the wages or delay in the payments of the wages to be heard by the appropriate authority who has been appointed by the government. So it can be the presiding officer of any labor court, or the presiding officer of any industrial tribunal, or it can be any commissioner from the workmen's compensation. So these will be the authority who have the permission to check, verify, and give the word, check the delays, if there is any delay, the mode of payment of the wages or the registers verification. All these things they have the authority to verify. And the district court appeals. So whenever the an appeal against the order of the authority dismissing the claim, application either wholly or part shall be within 30 days of the date should be filed with the district court of appeal, and no appeal shall be lie unless the memorandum of appeal is accompanied by a certificate which the authority that the appellant has deposited the amount payable under the directions of the appealed against. The court may, if it thinks fit, submit any question of law for the decision of the High Court, and it will decide the question in conformity with the decision. And these are the offences and penalties under the Act. So delay in the non-payment of the wages within the prescribed time, the minimum fine is 1,500 and the maximum is 7,500. And where there's any deduction in contravention, the same fine is applicable, 1,500 minimum and 7,500 maximum. And there is any contravention of the provision of the Act for the wage period, the same fine. And whoever being required to maintain the prescribed registers and the registers have not been maintained properly, the minimum amount is 1,500 and the maximum is 7,500. And whoever being required under the Act willfully obstructs the inspector or the refusal to produce any registers or documents, the fine might extend up to rupees 3,000. And the repetition of the same offense, the fine can be 3,750 to maximum of 20,500. And failure to or willful neglect to pay any wages, additional fine might be put upon along with the normal fine, which might be 750 rupees for each day for such neglect. So, we have certain miscellaneous provisions as well. So it can, no court can take cognizance of a contravention of Section 4, and no court shall take cognizance of any offense punishable under Section 20. No court can entertain any suit for recovery of wages. The power under the Act present by the state government can both can have both the powers of the central government in relation to the fields or mines or air transport or services. And we also have certain sections which have the authority which will be protecting. So no suit or prosecution or other legal proceedings can lie against the government. or any officer of the government for anything done. So in that way, we have different set of miscellaneous provisions which will try to protect and safeguard the interests. Now, coming to the method for computation and fixing the wages, it can be the monthly wages. Now, the monthly wages are calculated in the following manner: monthly gross pay, total number of divided by the total number of working days into the number of days the salary employee actually worked in the month, and it can be daily wages. Daily wages can be based on the basic rate of pay, and it is calculated, and it is a piece rate. Based on the piece rate, the wages will be computed and calculated. So the daily wages can be based on the basic rate of pay or gross rate pay. The basic rate of pay is used to calculate pay for work on a rest day or a public holiday. And for a monthly rated employee, the basic rate of the pay for one day is calculated in the following manner: 12 into the monthly basic rate of pay divided by 52 into the average number of days an employee is required to work in a week. So total pay earned without any allowance during the 14 calendar days immediately before the rest of the public holiday or outpatient sick leave. And this would be the pay for one day. And this is how they try to calculate the wages, and the payment of the wages is decided. Now we have the Minimum Wages Act 1948. So the Minimum Wages Act 1948 is a central legislation which is aimed at the statutory fixation of the minimum rates of wages in the employment. So we have the statutory board which will try to say that this is the minimum wage and the factories cannot pay anything less than the statutory wage fixed by the government. Now, need for the act, yeah, definitely the workman, illiterate, with weak bargaining power, they try to accept anything which is offered to them. So to protect their interests, the statutory minimum wage has been, the act has come to protect the interest of such workers. Now, the objects is to fix up the minimum wage fixing machinery convention. Uh, and the act also aims to provide social justice to the workmen employed in the scheduled employments by prescribing the minimum rate of wages. And the commencement of the act, it came into being the Minimum Wages Act 1948. It started its into enforcement on 15th March 1948. And the act applies to whole of India, and it is applied to, initially it was applied to agricultural employment and 12 other employments. And now the appropriate government has empowered to extend this act to any other employment in respect of which it is of the opinion that the minimum rates of wages should be fixed under the act. And coming to the definitions, we have adolescent. Adolescent is a person who has completed the age of 14 years and he has not completed the age of 18. Adult, a person who has completed 18 years of age. A child means who has not completed 14 years of age. Appropriate government, the appropriate government means for the schedule of the employment approved or under the authority of the major port or oil field or mine or railway administration. Now, employee means a person who is employed for hire or reward to do any work, skilled or unskilled. And employer is a person who has actually employed the workman for the work. So it can be a manager, it can be a supervisor, it can be the person who is in charge. Okay, so all these people come under the employer. Schedule of employment is nothing but it is an employment specified in the schedule or process or any branch of the work forming. And the wages means the remuneration capable of being expressed in terms of money. So the money value and that will be excluded, and any contribution paid by the employer to the provident fund, value of any traveling concession, and sum paid to a person employed to defer special expenses, and the gratuity payable on discharge. So these are the things which will be not included in the payment of the wages. Now, coming to the fixation of the minimum rates of wages, we will continue this in the next class. So I hope there are no doubts. So I'll stop sharing.